Standing Committee on Access to Information, Privacy and Ethics.
Taking place in a hybrid format pursuant to the House Order of June 23, 2022, and therefore members can attend in person in the room and remotely using the Zoom application. Should any technical challenges arise, please advise me. My understanding is we have nobody on Zoom, so this should be fairly easy. Please note that we may need to suspend for a few minutes. I'm reading what I have to read, as we need to ensure that all members are able to fully participate. Pursuant to Standing Order 1083H and the motion adopted by the committee on Monday, May 16, 2022, the committee is resuming its study of access to information and privacy system. In accordance with the committee's routine motion, the connections tests have been dealt with, so I'm informing you of that now. I'd like to inform and would like to now welcome our witnesses for the first hour today from the Treasury Board Secretariat, the Honourable Minister Mona Fortier, President of the Treasury Board. Welcome, Minister. Stephen Burt is here, Chief Data Officer and Assistant Deputy Minister, Policy and Performance Sector, and Catherine Luello, Deputy Minister and Chief Information Officer of Canada. Minister, you have 5 minutes to address the committee. The floor is yours. Please go ahead.
Je vous remercie, Monsieur le Président.
Thank you, Mr. Chair. Before I begin, I would like to point out that the lands on which we are gathered are part of the unceded traditional territory of the Anishinaabe people. I would also like to thank the committee for inviting me to speak here today and for your work on this issue. I am also grateful for the work of the Information Commissioner, and I met her last month. Public access to government information is essential to democracy. As Chair of the Treasury Board, I am responsible for ensuring that the Access to Information Act and the Privacy Act are administered by more than 265 government institutions. Our government is proud to have passed the first reforms to the legislation in over 30 years, which gave the Information Commissioner the power to make orders, eliminated all fees over $5, and established a system of proactive disclosure of information. Now, the Open Government Portal contains about 37,000 records and 2 million proactive disclosures. The Global Data Barometer ranks Canada 7th in the world for open data. Our legislation has also framed the requirement for a review of the Act every 5 years. This creates pressure for continuous improvement. 70.7% of requests were completed within the time frame of the law in 2021-2022. I'm not the first to say that this compliance rate is not good enough. The first review of the Act was designed to consult with Canadians and, in particular, Indigenous people to learn more about the access issues they face. The Commissioner's comments were also taken into account. I want to clear up a misunderstanding. The purpose of the report was to identify challenges, not to set out an action plan. The review is the basis for the work we are currently undertaking to improve the system. The objectives of this work are to improve service delivery, to strengthen staff, to better meet the needs of Indigenous populations, and to continue to develop actions such as declassification. As soon as I am able to share more information about our action plan, I will be happy to come back to you.
Have a unique relationship with the ATI regime, and Indigenous peoples should have a greater control over their information. The review identified several needed changes, including broadening the narrow definition of Aboriginal government in the Act and ensuring ATIP practitioners have the tools to deliver consistent services for those exercising their right of access. Mr. Chair, some have advocated changing the Act. My current priority is to improve administration of the existing law. We strengthened the Act less than 4 years ago. We have a lot of work to do to address the underlying systemic issues, and we will continue to take action to do just that. We recently launched an enhanced ATIP online platform to make it more efficient to submit a request and receive records while reducing administrative burden. And we have onboarded 251 institutions onto the platform, with more to come. Within a year, over 90% of requests will go through the platform. And TBS has also selected 2 modern systems that will provide faster processing of requests. Now, the first 13 institutions are being onboarded to the new processing software this year. And the more we automate where we can, the more our teams can focus on their core job, and the better the public will be served. Now, to help address staffing challenges, we launched a new community development office to support the ATI communities through recruitment, retention, training, and professional development. Mr. Chair, I would also mention that we are continually improving how the privacy program is administered by providing new tools and guidance to government institutions. And I look forward to continuing to work together on Canada's access to information system. My officials and I would now be pleased to answer any questions that you may have. Thank you very much.
Thank you, Minister. Under time, which we appreciate. I'm just going to remind all committee members, a lot of interest in this, both publicly and within this room. Convention around here dictates that the equal amount of time for the question to be posed is an equal amount of time for the answer to be given. I'm going to do that. I'm also going to be strict on the timelines as well for the questions, because we do have votes this afternoon, so I want to be mindful of that we're able to get in both panels. Mr. Kirk, you have 6 minutes to begin.
Thank you very much, Chair. Thanks, Minister, for coming before this committee. I'm going to ask you the same questions I asked every witness that have appeared before this committee. A couple of foundational questions, I think. First, do you believe that access to information, and specifically an ATIP system, is essential in a well-functioning democracy?
Yes.
Do you believe that Canada meets the standard that would ensure that that is in fact the case?
I believe we have updated the legislation 4 years ago, and we are improving the system, and it continues to be necessary that we improve it.
There's rarely do witnesses agree on something, but Madam Minister, it's interesting because virtually every witness that appeared before this committee answered no to the second question. So it's concerning that we have a massive disparity, I think, of understanding, and specifically your report. And I guess I appreciate the fact that you said you identified challenges without providing any solutions. Madam Minister, it's been 8 years, and along with your predecessors in this portfolio, Canada's access to information system is struggling, it's failing, and it's causing a loss of confidence in our democratic institutions. So, Madam Speaker, Mr. Chair, through you, do you, specifically when it comes to the retention of staff, that's a huge issue. You mentioned some metrics that you're doing to help recruit staff to fill those roles. Can you tell me how many staff are working in the ATIP system today?
Well, first, thank you for laying out many of the things that we have been looking into. As we did a review, we made many conclusions, and those conclusions demonstrated that we need to make sure that we have a digital system that will support how we treat ATI requests. Also, we've been working very hard on focusing on getting staff trained, trying to find more staff. So we have a pool of 150 potential candidates that could come and work with us to make sure that they're ready to confront the load that we have currently.
So you didn't specifically answer my question. Are there more ATIP officers today versus when you took over the portfolio, yes or no?
Yes.
Okay. The use of consultants specifically, are there more or fewer consultants being used across the ATIP system in government today than when you took office?
Fewer.
Fewer. Can you identify what the cost of those consultants is today versus when you took over?
I can tell you that we have a very important number of staff across the departments that are working very hard, and we're complementing the work with a few consultants to make sure that we get the job done.
A former ATIP officer had referenced to me the fact that when the Liberals took office, they removed many of the performance metrics that were associated with what they felt was very important to be able to effectively accomplish their tasks. Those performance metrics and some of the ways that they were able to track the ATIPs, when those were removed, it caused some chaos and confusion within the ATIP systems of a number of departments. I'm wondering if you could comment on that.
I can comment on the fact that we have, in the last year, answered to about 70.7% of the requests as taking out IRCC, because that represents about 80% of the requests, so we don't put it in that metric. And we know that we have a lot of work to do to make sure that we increase the numbers that we receive. And everyone knows that we have received an increased amount of requests and are trying to deal with the backlog, explaining why we're putting in administrative support, such as digital, and Catherine with my team could explain what exactly we're doing. And we're also making sure that staff can have the necessary tools to be able to process them.
So it seems to me that there's, again, a disparity of understanding from what you're saying today versus what's happening on the ground. To go back to the consultants issue, I'm just curious, could you provide us with a number as to how much, because I've tried to get this information from other sources, wondering if you could provide a number as to how much, maybe over the last 3 or so years, has been spent on ATIP contracts to outside consultants?
I can tell you that I don't have that number with me today, but it's something that we could provide. The most important thing right now is to know that we have lesser consultants than we did 10 years ago, and we are working on making sure that they complement the work that is being done by departments. I don't know if my team want to answer with.
So just because time is short, so you're confirming that you will provide that information. Could you also provide who received those contracts?
I guess so. It should be part of something that we could provide.
Thank you very much, Madam Minister. Cabinet confidences are a massive frustration across the board, it seems. Can you, in about 30 seconds you have left, talk about how, if they're to ensure that cabinet confidences is managed well within the ATIP system? Because right now we're seeing a whole host of witnesses say that seems to be a roadblock to getting information.
Well, the most important thing is we need to make sure, and I think the Supreme Court had ruled on the fact that it's important that Cabinet has a way of being able to express freely during the meetings. Therefore, that's why Cabinet confidence is important to keep. But there is a balance in where in the last legislation there was a proactive proactive disclosure, thank you, of cabinet documents, and we are providing briefing notes and those type of documents.
Thank you, Minister.
Point of order, Chair.
Go ahead, Mr. Barrett. Point of order.
Would you be able to just verify with the minister that her simultaneous interpretation device is working correctly? It just looked like that there was a challenge.
I'm sorry,
with
I'm
it.
deaf and I'm having a hard time hearing what your guys are saying, not necessarily simultaneous.
It just looked like there was a technology issue, and I just wanted to give the minister the opportunity to have that remedied before the next question round.
Thank you. I think that clarifies it. Thank you, Minister. Thank you, Mr. Kirk. Ms. Hepner, you have 6 minutes. Please go ahead.
Thank you, Chair, and I want to also thank the Minister and her team for being here to answer our questions today. I've spoken in this committee before about my previous experience with access to information as a journalist, and that was 25 years ago. The system wasn't perfect. It took a long time, it took a lot of money, and often you didn't get any relevant information back. So it's not like it's been a steady improvement. It's not like another government has done better in terms of ATIP. In fact, this is the first government in 30 years to improve the system in any way. And I'm wondering if you or perhaps your staff could talk about how you've managed to address some of the systemic barriers that are in this system and improve some of the administrative tasks with regards to access to information. Does that make sense?
Well, yes, thank you for your question. And just let's remind Canadians that are watching today that C-58 was adopted by our government 4 years ago. And we are in a process of course, reviewing the Act. And many of those decisions at the time gave more power to the Information Commissioner, and also the fact that we were able to eliminate all fees beyond a $5 application fee. So I would like to now turn on the fact that since then we've been putting a lot of efforts on working on the tools that we need to process, more administrative tools that we need to bring forward to reduce the burden and the load that we have seen increase over the years. For example, we have now the portal, the Open Government Portal, which is really helping in getting those requests done quicker. We have also, as I said earlier with the earlier question, tried to give staff more tools by training them and giving them more opportunity to manage. We also, and maybe I'll turn to Catherine to maybe talk about the digital aspect if we have time to do so.
Thank you, and this is my first appearance in front of this committee. Thanks for having me this afternoon. I'm still a relative newbie to government, less than 2 years as the Chief Information Officer of Canada, joining from a 30-year career in the private sector. And so this is a space that's incredibly interesting for me. We are dealing in an analog problem in a digital world, and that's to build on what Minister says. We're dealing with a lot of paper type of records that we're trying to provide access to Canadians, and we're doing so in trying to migrate into a digital world. So the minister has highlighted the fact that we've set up this portal. We are intending to fully onboard all departments within government, so Canadians have a common front door into the process. That's an aspiration we have for digital right across government, and to provide processing software, as she noted, that's going to be helpful to automating. And really that is at the core of the talent crunch that we're in right across some of these more expertise related areas, is trying to move as much as we possibly can to an automated form, including some of the service requests that we're seeing as part of the access to information requests, such as immigration status. Trying to really stand those up as services is a big part of how we want to tackle. The report sets out conclusions, but it has not stopped us from advancing things while we're looking and building out an action plan. Thank you.
Thank you. And Minister, you spoke in your opening statement about the proactive disclosures that your department has been able to do. Would you also talk to us about declassification of information? We've heard a lot from witnesses about the importance of declassifying some information. And what work has your department done in that field?
So as you probably heard from several witnesses also, as we've been hearing for a while, declassification is really an important part of the work to improve the ATI system. And as you saw in the review, a systemized approach to declassification supports government transparency and accountability and enhances access to Canada's history. We know that we put a declassification pilot with public safety to examine how that could be working, and we're still looking at how the pilot might guide us and how we can continue with the classification. And I know that the Commissioner, while she was at committee, commented on the work that we've been doing and said it was a step in the right direction. And when I met with her, we had a conversation about it. It's really important that we continue to put effort on how we're going to treat declassification. And I actually would like to invite the committee during your study to maybe guide us as we look into the next steps of declassification.
So it seems to me, and I've only got about 30 seconds left, if you could just comment, through C-58 was a start, and really the government is working on improving the system that has been, increasingly backlogged for more than 30 years.
Well, it was had been changed since 30 years that you just mentioned. We made some changes and we're looking into, and the review helped us to make some conclusions and find out also by stakeholders, the Canadians, and especially the Indigenous peoples on how we need to move. And hopefully very soon we'll be able to share an action plan that will make what next steps we will undertake for the administrative purposes and also looking at possible legislation.
Thank you, Minister. Thank you, Ms. Hepner. Monsieur Villemur, vous avez la parole.
Mr. Villemur, you have the floor. Microphone, please. Mr. Bird. Miss Minister, will you be doing an in-depth review of the law? With C-58, we committed to a review after 5 years, and I believe that we're currently doing that work in order to see how we can make changes. We have tools, and the digital system is so important, as Catherine mentioned. Often we were working with paper documents before, but now a lot of the data has to do with meetings on Teams, databases. So maybe not social media, but this is not only paper anymore. And so we're implementing administrative tools so that we can improve the system. I hope that that answers your question in part. Will you be committing to a reform before the end of this session? I'll be providing an update before the next year with the review that we just completed and with the work that you're doing as a committee and with our priorities and our action plan that we'll be presenting. We're going to see how we'll be able to continue improving the system. You've mentioned the action plan twice. And when you say that it'll be implemented soon, what does that mean? I can say that it should be by the end of this year. That is one of my priorities in improving the system. Many of the witnesses, including the commissioner, well, I asked the same question. Does the government have a culture of transparency or secrecy? And witnesses and the commissioner all said that it was rather a culture of secrecy still, that documents were being proactively redacted. Will you, in reviewing the Act, state that the system is based on transparency and openness? That's always what I say, and thank you for the question. We want to have a culture of openness and transparency and accountability. We want to be able to protect private information. That's very important. And so we need to strike a balance. What would be important is to redact. When we're redacting documents, it needs to be done following principles that will be in our directive. Perhaps that my colleagues could share some examples with you and tell you how important it is. There's an American study in the Foreign Affairs magazine that talked about the costs of excessive removal of information, but how do you find a balance? I could give you an example of how we support public servants by offering training so that they can follow the TBS directive. I would say that this culture of openness is directly linked with keeping documents that need to be classified. It's not possible to have everything be open. We do want to share as much information as we can, but we need to go through these documents and see what needs to remain classified, for example, with cabinet confidences, and continue to have discussions. A secret is defined as what needs to be protected because it is fragile and dangerous. But in the current culture, I'm hearing transparency and openness, and I see it in the report, but witnesses have said that that's not what they're seeing. So I'm wondering if this transparency and openness is nothing but a slogan. I think it's very important as a guide and a principle, but accountability as well, with openness and transparency. As my colleague mentioned, we want to have a directive in order to frame the work of our public servants, and we will continue to endeavor to make sure that they follow it. I agree with you. Openness, transparency, accountability, it's going to be difficult to find that balance, but I want to know how you manage all of this, because I agree with you, but I want to know how it's managed. The committee wants to have recommendations so that people can rebuild their trust in the system. So how do you juggle those three priorities? You have 10 seconds. I'll be brief. It's like brakes on a car. If you want to drive quickly, you need to have good brakes. So you need to see what you can do when problems arise. It's always a matter of examining all of these basic factors in creating programs. Thank you.
Mr. Green, you have 6 minutes, sir. Go ahead.
Thank you. In an article titled Treasury Board's Overdue Review of the Access Act is big on propaganda and light on recommendations. It had been stated that the review was a delay tactic to prevent meaningful changes to the access legislation. Your review, in fact, has no legislative amendments. Do you believe that no legislative amendments are necessary to achieve the outcomes that you've stated within the report?
Well, first of all, thank you for the question. And also, I'd like to say that when I had the privilege of being president of the Treasury Board, we were looking at that review, and we did it in 2 steps. Importantly, we needed to do the review, and then we realized we really needed to have an opportunity to engage with Indigenous peoples. That is why, partly, we took the time to engage with Indigenous peoples and making sure that they were part of this review. The conclusions are going to be very helpful in determining, and I had mentioned this earlier, on how the action plan will look into what next steps Treasury Board will be undertaking on the administrative approach.
The question is quite clear. Do you not believe that there needs to be legislative amendments in order to strengthen up the access to information?
Well, I believe that in C-58, we said that we'd review.
That was 4 years ago.
Yeah,
I'm talking about now.
It's in 5 years that we have it. We will be taking the necessary time to propose the next steps. And for me, right now, administrative
So, Mr. Chair, I'm going to take my time back. Thank you. No, you have the time that I've allotted in the question to the answer, and you've exceeded that. So, you've talked about engagement as being part of the reason why you've delayed providing legislative amendments, and yet many submissions provided included recommendations for legislative amendments. Do you believe the report is representative of the public engagement that occurred?
Well, first of all, to answer the question, we will look into how and if we can bring forward legislation changes. At this time, I was saying my priority was to make sure that we continue to reinforce the work that we're doing have.
So as the Public Service Alliance of Canada has announced that over 155,000 federal public servants will go on strike on Wednesday if a fair deal is not reached by the government, what impacts would a potential strike have on the access to information?
Well, thank you, and I know that they are working as we speak very hard, both Treasury Board and PSAC, to reach a deal. As you know, at the before the mediation started, we always look at what will be the essential services that will be offered during a strike, and this is not deemed as an essential service in the understanding that PSAC.
So just for the record, Mr. Chair, the PSAC has gone 3 years without a contract. Is that correct?
Are we talking about the review right now?
I'm asking you a supplementary question to my follow-up.
Since 2021, the 4 groups that we're dealing with, I'm dealing with 28 agreements right now. So the ones that we're dealing with today are 4 groups that have not, we're looking at for 2021 to the next 3 years or maybe 4 years of a deal.
Okay. In her appearance before the committee, the Information Commissioner stated that a model that gives the Minister of Finance and the Prime Minister the power to limit the required funding of agents of Parliament is contrary to our oversight role. Do you agree with the Commissioner in the matter in which the ATI regime is funded should reflect their independence from Cabinet or any particular minister?
Well, I think we should be. It should be known that our government believes into funding the ATIP and the Information Commissioner, as we increased her office's funding by 54%, and therefore, as you know, we will continue.
The question was about independence of the funding, not about the amount of the funding. So I'd like you to answer the question on whether or not you agree with the Information Commissioner on whether the model that would separate and provide independence in funding from the Prime Minister and the Minister to this agency would be perhaps better served for the independence of the office.
I thought I was clear by saying our government
No, you were clear that you funded them, but you weren't clear on whether or not you supported
yes,
the information.
Yes, the government supports the independence of the Information Commissioner and appreciates, of course, her important work.
So with specificity, because words matter, Madam Minister,
yes.
We've done this a long time. I'm going to ask you very clearly and very slowly, do you agree with the Information Commissioner that they should have an independent funding body absent of the Prime Minister and the Minister in order to keep their independence, yes or no?
We, of course, discuss budget requests through Cabinet confidence, and I am not in privy to say if we will give her independence in funding, but we do recommend
you can agree with the notion.
Independence of the Information.
You can agree with the notion without hiding behind Cabinet confidence, quite frankly. You can agree with the general philosophy.
But again, budget requests
length,
are not in my privy. Therefore, I would.
So as the President of the Treasury Board, you don't deal with budget requests? Is that your submission to this committee?
I believe the Finance Minister is the one who
You don't deal with
budget.
any of them? You don't sign off on the...
I do not sign off on the budget decisions. I sign off on the I work with the operations of what the Minister of Finance and the Prime Minister decide for budget. I work with that.
I served on public accounts and recall the relationship quite clearly. Thank you.
Okay, thank you, Mr. Green and Minister. On va commencer avec le deuxième tour.
We're going to start our second round. Mr. Chair, if I may, it's important to be honest. My colleague shared with me that I may have misled the committee. If you would allow me to make a correction to what I said.
Make sure that I clarified the remarks that I did at the end of the first round, Mr. Chair. C-58 introduced legal requirements for proactive publications that apply to ministers and not to cabinet. I used the word cabinet, so I just wanted to make sure.
Thank you for the clarification, Minister. Monsieur Gould, vous avez 5.
Mr. Gould, you have 5 minutes, please. Thank you very much, Mr. Chair. Thank you, Madam Minister, for being with us today. In your opening remarks, you mentioned that we were 7th for open data. Is that globally? Is that with comparable countries? How many other countries are on that list? What is it based on? I'm going to ask my colleague. It is globally, but I'm not sure how many countries are on the list. It would be interesting to have that, because there are countries that we wouldn't be able to compare to. If we're 7th of 150, that's great, but if it's 7th out of 22, that's not as great. You talked about opening files and closing files. Because when people ask for access to information, we often hear complaints on how long it takes, that it takes weeks, months, or years. Can you tell us more about that? Thanks for the question. We can state that the number of requests closed are increasing, but it's not following the amount of requests that we're receiving. ATIP requests have increased, and we keep reminding departments their obligations, and public servants of Treasury Board are continuing to work with institutions to support them with recruitment, with... Apologies, Madam Minister. My question is, how long does it take to close a request? 4 months, 6 months, a year? Do 50% of requests receive an answer in a year? So 66% of requests are closed within 30 days. That is separate from immigration, because immigration, IRCC represents 80% of the requests, but for all the other departments, we're talking about 70% rather. For TBS, the percentage is higher for files closed in 30 days. And we can make a request for an extension after 30 days. You talked about IRCC and your department is responsible for access to information, but IRCC had received emails that were being sent to inboxes that were no longer being used, or to incorrect email addresses. Have you put in place any measures to avoid such a situation in that department or in other departments? Thank you for asking that question. I'll ask Stephen to respond to your question. I will come back to what Ms. Luello said. What's important with IRCC is to have individuals' files in their own system. People need a safe system for them to have access to their data, and it would allow them to see where they're at in the system. They're currently working on this, so they want to have a new system for that and then another system for all ATIP requests. It's very important because, as you know, Madam Minister, we have a lot of immigration files that end up on our desks. And oftentimes, we've noticed that emails were lost in inactive inboxes. Do you have any statistics on the percentage of those files? I wouldn't be able to respond right now, but I could try to find that information. We all have writing offices, and we do see these cases. We are currently working on tools in order to deal with these situations. As I said earlier, a lot of things were on paper, and now we have all types of data that we have to go through. And that is why we are focusing on digital systems. And I would like to reiterate that we need to encourage people to not only make an ATIP request, but to also examining their files without going through the ATIP process. But Canadians do, of course, have the option to make ATIP requests. Thank you, Madam Minister, and Mr. Gould.
Please.
Thank you, Mr. Chair, and thank you, Minister, for joining us again today with your colleagues. Information management is essential to ensuring requests are completed as efficiently and effectively as possible what work is the government doing to improve information management?
Well, thank you for that question. And again, during the review, it highlighted that information management requires improvements to create a more efficient ATI system. And we've identified several key actions to address some of these issues. For example, including the building operational capacity through recruitment, training, investing in modern IT software, and enhancing practices and directives. However, I do and we must recognize that much more needs to be done to improve the access to information regime, and a more consistent strategic life cycle management of the Government of Canada's information could yield broad improvements across government and service delivery and program efficiencies. Therefore, we're really looking on how we can make sure we reinforce the system and strengthen it.
Thank you. And we've heard from several witnesses, including the Information Commissioner, on the importance of a declassification system. What work has been done to move forward with the declassification?
So again, as we said, declassification is an important part of the work to improve ATI system, and we have done a declassification pilot with public safety. I might ask Stephen to share a little bit of what we learned or found out, but then know that this will help us guide on the next steps for declassification.
So yeah, I've had the privilege of working on both sides of the declassification file, both from a national security standpoint and now as Chief Data Officer for government. What I would say is the pilot project has shown us some of the challenges of looking at historical files and declassifying them and the kinds of resource it requires to actually do that work. I would invite the committee in the course of your review of the Access to Information Act and the report to consider what recommendations you might want to make to us as we move into this action plan that the Minister has referred to here. There is a need for some policy direction, and when you look at what is happening in the international domain in declassification, there's some very rigorous policy setups out there. The U.S. in particular has automated declassification, systemic declassification, and then a mandatory declassification regime. I think we need to look at what the options are that would suit Canada and figure out where it is we need to go in this space in order to set the right course for that action plan.
Thank you. And we've seen and heard that changes through C-58, while improving transparency and openness in government, has changed the nature of requests. Can you elaborate on the changes of these requests and how it impacts overall ATI system?
Well, I think we just mentioned, for example, with IRCC, many are trying to find out what's happening with their cases, so they're going through ATI requests instead of, being able to look on the service side. That is one thing that we're trying to find ways to reduce that burden. There might be others that my colleagues could give as examples, because I think that's where we're at right now. Catherine? Oh, Stephen?
Yeah, I guess I would say access to information is like many legacy services to Canadians, where we need to move it from an analog system, as Ms. Loyola said, into a digital service line. Access to information is an important right, an important principle of the functioning of a democratic system. But there are many things that are coming through access to information now that could more properly be dealt with, more easily be dealt with as a service to Canadians. The IRCC situation is similar to having to do an access to information request every time you want to see your taxes with CRA. Right? It simply isn't a sustainable model for how you deliver a modern service. So we need to think about how we actually move more things into that channel.
Do you want to add, or?
Just to give comfort that that program in terms of how we're modernizing the technology and immigration is well in flight. So again, we're not waiting for action plans to take place. We're working very closely with our IRCC colleagues to better digitize that experience.
Okay. Thank you, Ms. Luello. Thank you, Mr. Baines. Mr. Villemure.
Monsieur Villemure, you have 2.5 minutes. Thank you very much, Mr. Chair. Thank you to all the witnesses. I wonder, all the changes that are being implemented, is this a sincere effort or is this just doing the bare minimum? I take this very seriously. On March 7th, the Information Commissioner stated that she doubted what would happen because it's not in any of the minister's mandate letters. It's a priority for the government, and I have the privilege of having this task to work on. And it's a privilege for me to come here and speak with you and to also support the team that is working on ways to strengthen the system. And I take it very seriously. It is a priority for me. I was able to discuss this with cabinet members and with those who think that we need to continue to strengthen the system. Thank you. Again, with the Information Commissioner on March 7th, she stated that C-58 gave her the power to make orders, but they're not respected because it doesn't carry the same weight as a court. So do you believe that the legislation should be amended to strengthen her powers? Answer: she can turn to the federal court in order to force an institution to comply with her orders, but currently she has not made use of that option. So it's up to her to do so. She can do it. Yes, she can. She hasn't done it yet, to my knowledge. In the report that you published, there were comments on exemptions and exclusions and that they weren't applied uniformly or that things were misunderstood. What have you done to resolve this situation? Can you give a bit more information? It's, again, what the commissioner said. She mentioned that Treasury Board's report had comments on exemptions and exclusions that are not applied in the same way, but there were no recommendations to solve the issue. I understand that there are no recommendations in the report. I'll let Catherine respond.
And I think that is one of the challenges in this space is that you have departments individually interpreting exceptions and exclusions. And so part of what we have done is given guidance to the town on how we would like to have things applied, as well as the minister's already referenced training that were available. Stephen, anything you'd like to add?
Merci. Merci, Mr. Villemure. Mr. Green, 2.5 minutes, please.
Thank you very much. And Minister, you cited the need for Indigenous consultations for the work that you're doing right now. I want to reference the What We Heard report. In that, there were many conclusions in relations to advancing Indigenous reconciliation, which could be interpreted as vague or making broad claims about being committed to facilitating, supporting, furthering Indigenous-led information and data strategies. Why were more specific recommendations reflective of the 8 Indigenous-specific submissions not included?
So again, as we did a very thorough, I believe, approach to Indigenous peoples to be able to have their participation in this review was the most, in the engagement and the outreach was very important. And the conclusions brought forward that that we take measures necessary to ensure that federal laws are consistent with the declaration. Actually, this is linked to UNDRIP because we also have to
That's a specific question. I'm going to need a specific answer, and it's regarding the 8 Indigenous-specific submissions. Why were they not included in your recommendations if Indigenous engagement and consultation is important to you?
So we had 2 reports. The first one was the first review, and then we wanted to make sure we had engagement with the Indigenous peoples, which was a second review, and then we brought all that
Was the second review the What We Heard report?
Yeah.
Okay, so in that, there was feedback that you were also receiving information from non-Indigenous entities as well. What is the purpose of consulting non-Indigenous entities on issues specific to Indigenous people?
Sorry, I'm going to get you to repeat the.
Indigenous and non-Indigenous.
So there was two consultations, one that was done with just general population,
Correct.
and we published a What We Heard report.
Yes.
At that point, we reoriented and said we really need to go and speak with Indigenous communities. We went and did that engagement over a period of about 9 months.
Right.
Published a What We Heard report out of that was included with the final report that you're referencing.
Were there non-Indigenous organizations consulted on the Indigenous-specific What We Heard report? And if so, how many and why?
We opened it.
You know, I don't know the answer to that question. We can certainly come back to the committee with an
Okay.
answer on that. I don't
Mr.
believe
Chair,
so.
let
but-
the record show that the Rotary Club has a precedent for phone interruptions, and I would like this member levied at least $25 for the good and welfare of the committee.
Mr. Green, for your intervention. I was thinking 50, but if you want to be benevolent and have 25,
Inflation.
then that's fine. Okay, we're done with the time on Mr. Green's round. I'm going to go. I did say 4 minutes. We're probably closer to 3 at this point. So just to let you know that we're going to go Mr. Couric. We may have Mr. Barrett intervene at some point, and then, sorry, Mr. Fergus, 3 minutes this round. Okay, go ahead.
Thanks, Chair. Madam Minister, have you ever filed an access to information request?
No.
So I filed a number, and 60% closed in 30 days is a pipe dream compared to my experience, just to give you some context. Bill C-58, I'm glad you brought it up. However, when hearing from witnesses, they had a very different experience, although, and in fact outlined quite a few times how a few disclosures and reduced fees seem to be a way to hide, for the government to hide behind increased secrecy in their actions. So in light of all of that, and we've heard a lot of criticisms of C-58, why is the criticisms from C-58, which your government passed a number of years ago, not included in your report?
Well, the important thing is we did actually bring legislation after 30 years of this law have not been looked at, and I believe that we also gave the Information Commissioner order-making power. We also, as I said, eliminated the fees beyond a $5 application, and also put into law a system of proactive disclosure of information from Minister's office, port authorities, and other government institutions. And we will continue that work to make sure that we provide a robust, or I should say an open, transparent system.
Thanks, Minister, but I think the point stands that the experience of many people who have used the system is certainly not what you're describing here today. I'd like to hand my time over to Mr. Barrett. Thank you.
Thanks, Chair.
Somebody else is
Madam
on his phone.
Minister, the Information Commissioner told this committee that your report was a summary of problems that are well known and have been identified for years. On what date will you present a list of solutions to those problems? And on what date will you have affected the completion of those recommendations?
I am comfortable to say that we will this year, later this year, be able to present the latest work that we have been doing, and also present a action plan to show how we can make progress on this.
Could you tell us in which quarter of this year you will provide us that?
I will tell you that I won't make any promises, but I will deliver this year.
Okay. Thank you, Mr. Barrett. Mr. Fergus, 3 minutes, sir.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair, and thank you very much, Madam Minister. I have a question for you, a bit of a sensitive question. When the Information Commissioner came before this committee, she talked about an assessment done by the Center of Law and Democracy. They stated that our access to information system, that Canada is 51st on the list with other countries. Is that assessment useful in assessing our access to information system? Thank you for the question. Briefly, I can say that that information is interesting, but it is not a useful scale. It only focuses on legal frameworks and not on operations. And I don't think that anybody believes that Russia and Afghanistan are more transparent than Canada because they are higher than us on the list. Proactive disclosure is important in an access to information system. Earlier, we mentioned being 7th for open data, and that is something that we should continue to examine. Madam Minister, as my colleague Mr. Couric mentioned, I have also sent in an access to information request, and I can say, to my surprise, I received an answer in 36 hours. It was very clear, very quick, and I got a lot of information. So we know that the system is facing challenges, but we should highlight those challenges and not exaggerate things in order to make it seem as though the system was useless. But we know, and as you mentioned, and I have a really quick question, the challenges that we have with the system when we look at requests sent to the Immigration Department, how can I say this? It doesn't reflect the average of access to information requests. I think that comes back to what I said earlier. Currently, in order to strengthen the system, we have a lot of opportunities to make administrative changes. Treasury Board is working on that, on how we can better make the data more available, how to digitize, and we're looking at an open portal that will be an essential tool to help us follow requests that are sent in. And there are other important changes that can be made on the administrative side. Of course, with the legislation we mentioned, after 5 years, there would need to be a review. But I think that we do have the opportunity to examine what we can do together, and I would like to thank the committee.
Yes.
Thank you, Madam Minister.
I do have a question, just to follow up on Mr. Barrett's question. When you say this year, are you talking about calendar year or fiscal year that we can expect?
I love that
that
question.
We can expect that.
If you may understand that we're working very hard right now to bring forward an action plan and also bring back to your committee, Mr. Chair, more information, and I will work as hard as I can with the team members to do this year.
Minister, you'll also know, Minister, that this is an issue that the committee has been dealing with since fall. The original motion was passed in June of last year. There's a lot of interest in this, and we've been hearing consistently about a broken ATIP system. We've asked the analysts, and we've received, just for your information, 26 recommendations in an interim report. We expect that, not just given your testimony, but also from the Information Commissioner and others that are coming behind you, that we will have far more recommendations than that for you to consider. And we are certainly looking for this system to be fixed. So
I welcome those recommendations, Mr. Chair, and I thank the committee, of course, of the work that you've been doing for such a long time, and we will be looking forward to looking at those recommendations and seeing how we can reinforce our system. We both believe in that.
Okay, thank you, Minister. Thank you, Mr. Burt, Ms. Luello, members of committee. We're going to suspend for a couple of minutes as we prepare for the second panel. Just remind everyone that we do have votes at around 5:45. I do want to get as much information in from this panel as possible. We'll suspend for a couple of minutes to set up. Thank you. call the second hour of this meeting. I'd like to welcome our witnesses for the second hour today. As an individual, we've got Mr. Ken Rubin, who's an investigative researcher from the BC Freedom of Information and Privacy Association. Mike Larson, who's the president. He is on Zoom today. And from B'nai B'rith Canada, we've got David Mattis, senior legal counsel, and Michael Wenig, who is a lawyer with Mattis Law Society. Now, just before we begin, we do have bells at 5:15, votes at 5:45. I'd like to get to 5:30, so if we can have unanimous consent at this point, just to go to 5:30, would that be okay, everyone? Okay? Perfect, thank you. Okay, it should give us enough time. Mr. Rubin, I want to welcome you for 5 minutes, sir. Please go ahead.
Yes, Mr. Chair. For a minute, I thought I was in a study session instead of a serious legislative committee, but I'm going to show you why you have to take things seriously. Since coming to testify nearly 6 months ago, several detrimental changes have occurred to the right to information. One is the refusal to call a public inquiry given the lack of substantive public information on foreign influence on Canadian affairs and elections. Another roadblock is the government accelerated use of artificial intelligence as part of their largely secretive data-driven decision-maker operations, which the minister was hinting at. There is also mounting evidence of secrecy in government contract outsourcing. That comes with the Comptroller General cautioning officials not to say or reveal much. New entities like the Canada Growth Fund are being set up largely outside the access to information regime. Public inquiries have released that show dysfunctional and secretive cultures of the RCMP and National Defence being allowed to flourish. In addition, the new federal employee hybrid workplace scheme makes processing access requests more difficult and less of an essential service. And finally, before the committee is the very late she didn't really get into it, Treasury Board review with no recommendations and no hope for any recommendations except some vague action plan. She only confirms that the government wants to impede and delay meaningful access reform. The truth is the Treasury Board has done an incredible harm over 4 decades, making full disclosures impossible. This committee must sanction Treasury Board for its inept, self-serving review and recommend Parliament remove it from having a central role in access to government records. In its place, the committee should recommend that an arm's-length Freedom of Information Agency be set up under a revised law to handle and promote public information disclosures. What is first required is that the right to information squarely and clearly be seen as a guaranteed constitutional right falling under the Freedom of Information section of the Charter. A transformative right to know act has to be immediate and full disclosure of health, safety, environmental, and consumer data, as well as the same disclosures for decision-making records and financial transactions and accounts. That requires quick access without fees. Should officials not honor their obligations for documenting, servicing, and disclosure, and try all kinds of creative avoidance, they must be subject to stiff penalties. The inclusion of broad coverage of agencies receiving or using public funds can no longer be ignored. What also has to come to an end is the broad array of exemptions and exclusions to access. Authorities have created myths about cabinet and bureaucratic operational records as sacrosanct. This must change as places like New Zealand show it can. Last time round in Bill C-58, what was created and needs to be undone was a retreat from fuller disclosure through a 2-tier system. It's a system where sanitized summary data and permanent exclusion of minister and the Prime Minister's office was falsely sold as a so-called advance. Ottawa needs to drastically change from a place of spin communications, closed-door meetings, and gagged employees. Canadians need a dramatic new way to access data and be able to participate in and know about Canadian government affairs. This committee and its 28 or so recommendations can help lead the way. Let's hope so. The minister isn't going to do it for you. Thank you.
Thank you so much, Mr. Rubin. Under time, we always appreciate that. Next, I have Mr. Mattis. You have 5 minutes, sir, to address the committee. Please go ahead.
Yes, thank you very much. I'm Senior Legal Counsel to B'nai B'rith Canada. I have with me Michael Wenig, who's here to help answer questions. Mr. Wenig has been working with another lawyer, B'nai B'rith, David Rosenfeld, on records requested that we discussed in our brief, and he's also helped draft our proposed amendments to the Access to Information Act. Today is Yom HaShoah, Holocaust Remembrance Day, and I welcome the opportunity to address the committee on the subject of remembering the Holocaust. Canada, as a member of the International Holocaust Remembrance Alliance, is committed to Holocaust remembrance. To remember the Holocaust, we must remember the victims, but we must also not forget the murderers. While the murderers are alive, that means bringing them to justice. Once they're gone, it means providing public access to the record of their atrocities. During the Holocaust, the murderers were in Europe. After the Holocaust, the murderers scattered around the world to escape justice. Thousands came to Canada. Howard Margolian, a historian with the War Crimes Unit with the Department of Justice, in his book Unauthorized Entry, estimated that 2,000 Nazi war criminals and collaborators entered Canada after World War II. Canada's program on crimes against humanity and war crimes, in one of its reports, stated that since the beginning of its work, the Department of Justice had opened and examined over 1,800 files. The efforted understanding of learning lessons of the Holocaust must never stop. For that history to be written, the files of those who have been identified to the War Crimes Commission or the Government of Canada or investigated by them must be made public. We have a duty to the victims, not just to remember that they died, but why they died, how they died. The picture of the memory we paint must be real and complete. That picture must include the murderers. Right now, we're woefully short of meeting that goal. The efforts of B'nai B'rith Canada to obtain access to relevant files and documents have been constantly frustrated and gone nowhere. One element is the Part 2 of the Commission of Inquiry on War Criminals. That Part 2 recommended urgent attention to 20 files and further investigation of 218 others. We don't have that Part 2. We don't have the names of those that were recommended, and we've asked for it without success. There's the follow-up to Part 2. What happened to those 20 cases of urgent intention and 218 cases of further investigation? We've asked for that. We don't know. There was a report commissioned by the Commission of Inquiry on War Criminals on the history of Nazi war criminals in Canada from 1940s to the present. Mr. Justice Jules Deschênes recommended that historical report be made public in its entirety, but it was not. There were substantial deletions through our access to information request. We've had some of them removed, but there's still significant deletions which remain. And then, of course, there's the 1,800 files that the Department of Justice and RCMP were dealing with. What happened to them? Who are they? Again, we don't have that information. We're recommending two proposals. One is to amend the Access to Information Act, which would mandate disclosure of records relating specifically to alleged Nazi war criminals in Canada and to any other Canadian resident who've been complicit in carrying out the Holocaust. And secondly, we're recommending the establishment of a publicly accessible digital archive of Holocaust materials by requiring all government agencies to compile and submit to Library and Archives Canada all the agencies' Holocaust-related records, and then require Library and Archives Canada to organize and place the records in a digital archive that is readily accessible to the public. Now, there is something very specific about the Holocaust archives in the European Union General Data Protection Regulation, which provides for specific public access to those sorts of archives. There's also some statements and policies and recommendations in the International Holocaust Remembrance Alliance about access to archives about the Holocaust, that they should be made available to independent researchers. And Canada, of course, is a member of that alliance. Philosopher George Santayana wrote, "Those who cannot remember the past are condemned to repeat it." Yet, we cannot remember a past which remains hidden from us. Only through public access to Holocaust archives can we learn lessons from those archives. Learning lessons from the Holocaust is a legacy we can create for the victims, creating meaning from the senseless death of so many millions of innocents. To learn those lessons, we need access to the archives which can convey them. Thank you very much.
Mr. Matus, right on time. Appreciate that. Mr. Larson, you're next for 5 minutes, sir. Go ahead, please.
Thank you very much. My name is Mike Larson. I'm the president of BC FIPA and faculty member in the criminology department at Kwantlen Polytechnic University, joining you from my office here in the unceded territories of the Coast Salish peoples. Grateful to the members of the committee for inviting us to speak with you again after our first presentation in the fall, and grateful for participating in the study of Canada's access to information and privacy systems. This is really important work, and we commend the committee for giving it its sustained attention. When I appeared before the committee in fall 2022, I provided an overview of the features of a strong and effective access to information system for Canada. We also provided a written brief focusing on 8 key areas for reform, law reform, to the ATIA. And since that time, the Treasury Board presented its Access to Information Review Report to Parliament, covering many areas for possible reform and further study. I'll focus my remarks today on just a couple of themes that warrant emphasis. The report addresses the importance of a professional framework for ATIP staff, and we call for investment in a culture of access and note that this requires adequate training, resourcing, and a real commitment to transparency at the leadership level, and that includes a consideration of how government responds to the work of this committee and to the Treasury Board report. Senior officials, elected representatives, and cabinet set the tone. When the release of information is selective and strategic, shaped by political considerations, or when witness after witness, commissioner after commissioner, and committee after committee describe the ATI system as broken, fallen behind, or dysfunctional, and the response is to leave the official status quo substantively unchanged, this comes across as an endorsement of opacity, not a commitment to transparency. The TBS report emphasizes the deep connections between trust in public institutions and the transparency of those institutions. From our perspective, this is absolutely foundational. A line in the report that stands out to us is, across multiple channels of engagement, input into this review, the greatest complaint about the ATI regime is poor compliance with the law. This is discouraging to read, but not unexpected. Focusing on improving compliance, while essential, often leaves us looking backwards, though, rather than at substantive reforms to the law that are necessary to build a modern access regime that serves the public interest. What kind of reforms? TBS report mentions a number of possibilities. In our review, though, there are some serious priorities. First, creating a legislative duty to document to ensure that core decisions are recorded. Second, embedding a strong public interest override in the Act. Third, imposing caps on extensions to requests rather than relying on the open-ended and nebulous reference to extensions for a reasonable time, and requiring commissioner authorization for further extensions. Fourth, shifting the exemption framework to reflect a harms-based approach rather than categorical or discretionary exemptions based on classes of record types. Fifth, following UNDRIP, removing barriers to access to information for Indigenous communities and moving towards Indigenous data sovereignty, particularly as it pertains to records pertinent to specific claims and reconciliation. And though it was not emphasized by the TBS, including all entities that deliver public programs or services under the scope of the Act, including the PMO and ministers' offices, and also ensuring that federal political parties fall under the scope of federal privacy laws, recognizing voters' rights to know about how their personal information is being used. And finally, radically revising and limiting the Section 69 exclusion of cabinet confidences and shifting it to a limited exemption subject to review. How governments approach the matter of cabinet confidences is a bellwether for their general position on transparency. I note that as we meet today, the Supreme Court of Canada is hearing an important case about whether the mandate letters issued to the Ontario Premier, by the Ontario Premier to his ministers, are subject to disclosure under FOI or whether they would be withheld as privileged under cabinet deliberations. Several provincial attorneys general are intervening in support of an expansive reading of cabinet confidence. BC FIPA is intervening in support of the public's right to transparency. The case reveals much about how Canadian governments at all levels think about transparency. It's absurd that in a democracy, documents such as mandate letters, which are essentially the marching orders for elected governments, can be withheld from public scrutiny. And yet this may be precisely what cabinet confidence exclusions permit. These are all core areas for law reform, and I really want to emphasize that. The TBS report also discusses administrative supports, modernization of technology and process, expanding commitments to open government beyond the auspices of the ATIA. These are all worthy initiatives, but they can't take the place of modernization of the law that underpins the right of access to information. We're at a crossroads for transparency in Canada. Trust in public institutions is eroding. FOI regimes are failing to provide public with timely and complete access to information. And some governments, notably BC, are actually backsliding by introducing application fees for FOI requests. Information that pertains to the public interest is parked behind broad exemption clauses or the brick wall of cabinet confidence. Our access system often functions as an impediment to reconciliation. On a hopeful note, and I'll conclude here, there's a great deal of consistency in the recommendations for reform that have emerged over the years. Indeed, I would argue a clear roadmap. And the question, therefore, is not what's to be done, but rather, will we act? And on behalf of BC FIPA, we hope the answer is yes. Thank you.
Thank you, Mr. Larson. Appreciate that. Right on time as well. So we're going to move to our first round of questioning. Mr. Barrett, you have 6 minutes. Go ahead, please.
Well, thanks, Chair. Thank you to the witnesses for being here today. Mr. Mattis, I want to thank you for drawing our attention to Holocaust Remembrance Day. I think that's incredibly important. I'm just going to use the beginning of my time to give the committee notice of motion, and I'll just read it into the record, and that's that the committee requests that the government table the following documentation in unredacted form, and that documents be published on the committee website. Part 2 of the Deschênes Commission report. Number 2, Alti Rodal, Nazi War Criminals in Canada, the Historical and Policy Setting from the 1940s to the Present, open parentheses, the Rodal Report, close parentheses, open parentheses, submitted to the Commission of Inquiry on War Criminals, chaired by Justice Jules Deschênes in 1986, close parentheses, and 3, all Department of Justice and RCMP Nazi war crimes files, including all investigation files relating to those individuals recommended for investigation by the Deschênes Commission. And that's the end of the notice, and I will send that to the clerk as well, and I'm going to continue with my time.
Okay, thank you, Mr. Barrett.
So my question, first question is for you, Mr. Mattis. Can you tell me, in your opinion, what you believe the government's definition of Holocaust-related records would ideally look like?
Sorry, Mr. Mattis. It's Mr. Mattis, just to be clear, not Mr. Mattis. So I just want to help you out there. Go ahead, sir.
Mr. That's an issue that has been addressed by the International Holocaust Remembrance Alliance, and I'm part of the Canadian delegation to that alliance representing B'nai B'rith, and I'm on the Access to Archives project, and so we've done a lot of work on that area, and there's some very elaborate and specific definition, and because Canada is a member of the alliance, normally they comply with what that alliance has recommended. So the answer to your question is there. It's posted. It's on the internet. It's detailed, and the government, I would say, should just adopt it.
And what, in your opinion, is the reason for their not having adopted it to this point?
Well, we don't have a Holocaust-related archive in Library and Archives Canada or anywhere. I mean, there are some private archives, but nothing public. I haven't heard them say they're opposed to doing it. They just haven't got around to doing it.
And by them not having gotten around to doing it, how has that affected your work, and what are the repercussions of you not being able to fully execute on the work that you've described that you're doing?
Well, I mean, that's related to your motion. I have been trying to, and with my colleagues as well, Michael Wennick and David Rosenberg and so on, trying to get access to these archives, and they are there in Library and Archives Canada, but they're not accessible, so we can't see them. I mean, it's a related problem that, I mean, obviously the archives should be grouped together, but they also should be accessible. I mean, if they're grouped together but they're not accessible, it doesn't help us very much. And so we need both. And I must say I welcome your motion, and I agree with it entirely, even though I can't vote on it.
I appreciate that, sir. What would having those documents mean to Jewish Canadians? The ones that are outlined in the motion, which just it won't be debated or voted on today. What would that mean to Jewish Canadians, and what would those documents being publicly available do with respect to education and awareness of the Holocaust?
Well, we're now entering an era where the survivors are almost entirely gone. I mean, there's some left, but not that many. And the survivors, while they were alive, were a tremendous educational force. But in the absence of the survivors, what we've got is the archives. So that the archives loom in importance with the passing of the survivors and of course, the perpetrators, too, to tell us what happened, to educate people. And it's not just telling people what we know happened, it's finding out more about what happened, because the history isn't complete until we've got the records and people can digest it and analyze it. And our history, I mean, we've got a lot of information about the Holocaust in Canada because we had so many survivors and we had so many perpetrators. And that's a story that remains to be told until we get access to the archives.
Thank you, Chair.
Mr. Barrett. Next, we're going to go to Ms. Hepner. You have 6 minutes.
Thank you, Chair, and I would also like to thank our witnesses for being here and sharing with us today. Mr. Matus, I'll come back to you. I want to thank you. I think it's very appropriate for you to be here advocating on this issue on Holocaust Remembrance Day. So I want to thank you for that. I met with some of your colleagues from B'nai B'rith in my office just recently and talked about this issue of declassifying Holocaust documents. And I think I understood, and correct me if I'm wrong, that the U.S. has a more open system. I'm wondering if you can talk about what they do differently south of the border, maybe lessons we can learn up here.
We do have specific legislation about this, which we don't. And so I think it would be useful to have an amendment to the Access to Information Act to deal specifically with that. And I mentioned, of course, that the European Union data regulation has something specific about that as well. So we've got precedents to follow in other jurisdictions. There's probably scope to do something in the present legislation. I don't feel that there's room for, obviously, interpretation and application of the legislation. So I don't think we need to wait for an amendment to get these records accessible, but it's obviously going to be a lot easier when there's a specific direction, and so that's what I would learn from that. I wonder if Michael Wenig, if you had something to say about this.
Yeah. So the U.S. legislation basically created an interagency working group that was charged with the duty to basically collect and organize Holocaust records from across the federal government and have the records be delivered to National Archives, and then mandated the National Archives to set up a public archive of all these records. So that was sort of the gist of this federal legislation. So it's quite progressive relative to what we have in Canada.
That's helpful. Thank you very much. I would like to turn to Mr. Larson next. We spoke about, you were talking about legislative changes, and what we heard from the Information Commissioner at this committee is that, in fact, legislative changes could exacerbate some of the problems that we're seeing in access to information now. Do you agree that we should begin with administrative reform and working out some of the problems and rolling out what we have before we tackle legislation?
Thank you. No, I don't think it has to be one before the other. You can do both at the same time. There's a lot of really good arguments to be made about improving the accessibility of the access system and the way this information is managed within government. I really take that quite seriously. We've recommended the same. But some of the core issues around cabinet confidences, exemptions, delays, these things have been recommendations before committees like this for decades. And so I think kicking it down the road any further is not really a good decision.
Okay. Sorry, I've only got a limited amount of time, Mr. Rubin. I'm going to move on. Mr. Larson, continuing with you, we heard from the president of the Treasury Board that digital technology and transitioning paper records into digital tools that we can access more easily is a big challenge for the department right now. Do you think that these new tools, the digital tools, are critical to address the challenges in the access to information system?
I think that they're very important. They have to, we have to be able to access the records, right, to locate the records that are pertinent to access requests. But ultimately, we have to make sure that the records that are released released in a timely fashion and are comprehensive and are not full of holes. And that can't be addressed exclusively with digitization. That has to be a matter of law reform.
Okay. You also spoke in your statement and in your today about the fees for access to information. In BC, I think it's gone up to $10, and I read in the Globe and Mail that since that $10 fee was introduced in British Columbia, there's been a drop in access to information requests by 80%, a drop from media, opposition politicians, all reducing their requests for access to information. Can you comment on what you think about that? Are you encouraged by the government reducing the fee to $5 or free if there's a financial challenge?
Oh, thank you. I jump at the opportunity to speak to this. It's a deterrent fee, right? I mean, this is not really a cost recovery fee. It's a fee that's designed to make people think twice before using the FOI process. In BC, we went from having no fee to really a mix now, actually, $10 for some organizations and public bodies. Others haven't implemented the fee just yet. As you say, there's been a real disastrous drop in the use of the Act, especially by journalists who are looking to use it for accountability purposes. My organization is actually filing more FOI requests now to monitor the effectiveness of the new regime under this situation. Reducing the barriers to access information is fundamentally important in a democracy, and a fee is a barrier. So we strongly support the removal of fees, and certainly would oppose any increase in fees, including in the federal ATI system. I'm heartened by the removal of processing fees as part of federal reforms, but really want to make sure that people are able to get accurate and timely access.
Thank you.
Thank you, Mr. Larson. Ms. Hepner. Monsieur Villemur, vous avez 6 minutes, peut-être.
You have 6 minutes. Perhaps you could get Mr. Rubin's answer if you'd like. Mr. Rubin, thank you for being here again. You heard the minister earlier. I asked her a question whether or not her efforts were sincere or not. Do you believe that the government is trying to take its time in order to avoid reforming the legislation?
I believe the government doesn't want to do anything except millions of dollars on digital stuff, which will make access to information harder, will make personal information and the consent of individual Canadians to give it harder. I think I have nothing against digitization, but when it's being done at the cost of millions of IT contracts and the enterprise architecture Treasury Board that the public knows nothing about, and now it's going to be called an action plan, and it's not legislative amendments, which gets, as Mike Larson is saying and the Canadians are saying, any more material. Why should we have to, as Mr. MP Barrett said, pass motions in committee or have public inquiries either mandated like the Emergency Rouleau Commission? Why can't we just, as average Canadians, get information? We can't do that because this government doesn't want to even start the process. They've had every opportunity to. The last time they retreated the bill, they didn't advance the bill.
Alors j'imagine que lorsqu'on
I imagine that you're skeptical about openness and transparency, and you share the Commissioner's opinion that there is a culture of secrecy here.
There's more than a culture of secrecy. There's a culture of corruption and conflict of interest, because once you start hiding, as I was alluding to, contracts, and there's been a lot of press about that, not just the sole sourceness, but, awarding your friends and so on. If you can't get the material material about that, and even on a timely basis get some of it, then you're having more than a culture of secrecy.
Et vous avez recommandé.
You recommended that there should be an independent access to information agency. What would it do?
Sorry, I didn't get the choice.
You asked Parliament to create an independent agency for access to information, and what would that institution do differently?
It's not coming through, unfortunately.
It's just what's the difference between an independent agency and what we have now?
Oh, what I'm suggesting?
Yeah.
It's like night and day. I mean, why would you want a cabinet committee called Treasury Board whose main goal is to repress information in charge of your access to information? If you had access officers who aren't being trained and more money put into the CD office to being brainwashed into gatekeeping so that there'd be more exemptions applied. If you had officers in a central agency who were trained, I mean, like say Mexico has a better system, they're there to promote and release information. They're not there to line by line try and delete information. So, and when you have agencies that are in need of extra services, you'd have the pool of people there. I think we have we've put the wrong cart and horse together here.
Merci beaucoup, M. Rubin.
Thank you very much. Mr. Larson, earlier you talked about trust eroding with the current process. What could we do in order to rebuild people's trust in the access to information system?
Thank you very much for the question. I think rebuilding trust is a vital step to be thinking about for this committee. One thing that can be done, I think, is to impose some limitations on the delays that are systemic in the system. Right now, the Access to Information Act permits open-ended extensions and consultations that can further exacerbate extensions. And in practice, what this tends to mean is people who are seeking to exercise their right to know and to retrieve records that will help them to make informed decisions and as part of a participatory democracy, are just met with nothing in many cases, a silence. And I think I said this in my testimony in the fall, but in a silence, people are feel free to fill in the blanks, right? In terms of speculation, in terms of conspiracy, in terms of ulterior motives. So imposing some clear timelines that are actually followed and enforceable, I think, is a vital step to be made here.
Auriez-vous d'autres suggestions?
Would you have any other suggestions or two other suggestions beyond the first that you just shared? Just two more suggestions, please.
Absolutely. Well, we have quite a few in our brief here. So the cabinet confidences issue, I think, also is an important one here. Many of the records that people are really interested in pertain to why government is doing what it's doing, how it's rationalizing those decisions, who's making those decisions, and on what basis. And let's be honest, a lot of those records actually do pertain to the deliberations of cabinet. Having what Mr. Rubin has characterized as a brick wall around cabinet confidences, I like that term, really does not serve the interests of the public's right to know. So definitely having some process so that this is no longer a sacrosanct provision, but something that can be contested as a legitimate exception, I think is important. The third thing I would say is imposing a harms test for the operation of exceptions, rather than having categorical exceptions that deal with certain kinds of information, right? So when information is withheld from the public, and it is our information, right? It's public information. When it's withheld from the public, it should be because releasing it would cause some kind of demonstrable harm, not simply because the government is exercising a power of secrecy.
Okay, thank you, Mr. Larson. Merci, Monsieur Villemure. Mr. Green, you have 6 minutes.
Thank you very much. And I'm going to put a series of questions to the witnesses. I'm going to ask them in a rather rapid-fire way. Don't be surprised if I interject to maybe take my time back and move somebody along. So I'm going to ask you to try to be brief because I want you to have the opportunity to get on the record for as many different questions as we possibly can. Mr. Rubin, in the preceding panel of witnesses, you heard me put a question to the President of the Treasury Board that responded to your statement that the legislative review appears to be, and I quote, a delay tactic to prevent meaningful changes to access legislation. Can you expand on that briefly?
Well, when you can't even bother to put some simple amendments on times, or even if it's cabinet records for 10 years instead of 20 years, when you can't even be bothered to do that much, then you're not seriously considering doing things. But at the same time, in that delay, you're spending millions of dollars creating this digital system It's called to leverage the way you want to do decision-making in the Canadian government in the future, which excludes more Canadians from knowing what you're doing.
And if we
then
could, just to be...
you've got more than delay, you've got deceit.
To be clear, I mean, we're making pretty loaded statements, and I want to give you a chance to substantiate them. You'd mentioned AI, and we've certainly studied that at this committee. In your opinion, what role or what harms could potentially be caused by the use of AI in this quote-unquote action plan that they have, or this modernization?
Well, it would help if they would, first of all, I mean, they've listed in some places the millions of dollars that are going to AI companies, but they've never documented throughout the government, including Treasury Board, what uses are being made of AI, which banks are there, and to identify the uses of them at least gives the public the idea of how much money and what the uses those are, because some of them do involve personal information. And so that's something that has to be done for sure.
And in your writing, you also mentioned that the Treasury Board conducted a study, which was an internal evaluation and audit, was not presented to those participating in the review. Was that part of the reviews that have been made public since then? Or are you privy to another internal review that you might want to?
I don't know. I thought the minister, like some of the documents I got early on, was they're going to make a big deal of doing early action. Like they're going to come and release some things, like maybe a public interest override or something, some SOP to Canadians. They have not done any of that. So those documents do exist, but they're not willing anymore to even consider doing those small changes.
Mr. Larson, you had talked a little bit about the role of cabinet confidence. I'll share with you, as a member of Parliament on the opposition side, I believe, it's my opinion, that cabinet confidence is a mere convention of Parliament and not a legislative precedent or a legal precedent, and that the House of Commons ought to be, the grand inquest of the nation and have complete access. That's not the case. In fact, we are often as frustrated as the regular citizen in trying to get basic information. So in your opinion, can you comment about how the role of the government of both being the client and simultaneously the solicitor, as was identified by the former Attorney General, presents a bit of a problem in unpacking the role of cabinet confidence and access to information?
Yeah, absolutely. I couldn't agree more that I would like to see our elected representatives able to cut through the barriers to transparency that are embedded in the convention, which is a good way of saying it, of cabinet confidence. I mean, previous governments and current governments seem to approach cabinet confidence as being something that's almost like a law of nature. It exists. It must exist. Even the Treasury Board's report we were referring to today has some of this language in there that changing it would require change across many levels of government. Well, okay, let's change it then. I think that there's lots of evidence to suggest that this doesn't allow for proper participation in the process. And look, if our elected representatives can't get the information they need to participate, you need to participate. Well, that seriously is not working.
And have in any of your kind of legal reviews, have you considered the increasing role, in fact, under this particular Prime Minister for the use of secret orders in council?
Yeah, I think, we absolutely have to have transparency about where and when secrecy is used, right? And so what we start to get is kind of a layering of secrecy so that decisions are not only opaque, but the basis of those decisions, the orders that inform those decisions are opaque as well. And this goes back to what I mentioned earlier about the issue of trust and transparency, right? Secret orders may in certain circumstances be justifiable, but as a principle in a democracy seem to run, roughshod against the principle of transparency and openness. So I think they don't do anything to help us in terms of trust in government.
Thank you. Your organization submitted 16 recommendations as a part of the public engagement process of the review, many of which were not reflected in the report. You may have heard me reference this to the minister. So in your opinion, why does the Treasury Board's conclusions differ significantly from the recommendations provided by those who participated in the public engagement?
This is not anomalous in my experience. Our organization makes recommendations on reforms to transparency laws provincially and federally. And one of the trends that we tend to see is when there is a public inquiry, when there's an investigation or a commission or a review, one of the first things that's presented is the administration of the act. And again, there are reasons to make those changes. What tends to happen is government then champions those changes. Look at what we're doing. Look how we're increasing transparency. Look at the ways in which this is improved. Lots of proactive disclosure, and meanwhile the actual system, the legal basis is left to atrophy. So without imputing any particular motives, I would say this is kind of par for the course.
Thank you, Mr. Larson. Thank you, Mr. Green. We're going to go probably another 10 minutes or so. I do have to leave time at the end for the budget on foreign interference. That should go very quickly. We're going to go 2.5 minutes each, if that's okay. And I'm going to go with Mr. Barrett first. Go ahead, please, Mr. Barrett.
Thanks, Chair. With 10 minutes left, I'm going to move a motion that was put on notice on April the 13th, that the committee immediately undertake a study and review of the Liberal government's decision to appoint the sister-in-law of a sitting cabinet minister who himself breached the Conflict of Interest Act in relation to a decision concerning another member of his family as the interim Conflict of Interest and Ethics Commissioner, provided that A, the study consists of a minimum of 3 hearings, B, the committee hear testimony from Martine Richard, the interim commissioner, Dominic LeBlanc, Minister of Intergovernmental Affairs, Infrastructure and Communities, and other witnesses the committee deems necessary, and C, the committee report its findings to the House. So that's been circulated in both official languages to members of the committee and met the notice requirements.
Okay, thank you, Mr. Barrett. The motion is in order. Keeping in mind that I do need to keep time for the budget, do you want to say a few words on that?
Yep. Thanks, Chair. So, look, the confidence that Canadians have in their democratic institutions is fundamental. And we have independent officers of Parliament who Canadians trust to serve as independent arbiters of what happens with government. And we've seen the important role the Ethics Commissioner has played since the creation of that office. And it added a level of accountability that wasn't there before. And though I would argue that higher higher standards need to be applied, we have standards that we have right now that need to be applied in a way that Canadians are sure is done in a manner that's beyond reproach, and that even the appearance of a conflict of interest is avoided in the appointment of the Officer of Parliament who's going to be discharging those duties and conducting investigations. So while I do hope that we can dispense with this motion quickly, with members of the committee having had it in their possession since Thursday of the week prior, I look to the committee. Hopefully we can get to a vote. But perhaps you'd like to take a moment to excuse the witnesses if this isn't going to come to a vote right away.
Yeah, I am going to do that. Thank you, Mr. Barrett. I'm going to excuse the witnesses, Mr. Rubin, Mr. Matus, and Mr. Larson. I want to thank you.
Can I ask a point of order? Can I just ask one thing of the witnesses, sir?
Please go ahead.
Yeah, just that if there were rebuttals to some of the questions that you didn't have an answer for, I just wanted to extend to them that they might be able to provide in writing, because I feel like you got cut off, and you'd be able to provide in writing any supplementary responses to any of the points or questions, if that'd be okay, Mr. Chair.
Yeah, I appreciate that. And if the witnesses do have anything that they would like to submit to the committee, please do. This is an ongoing study. I know we have another study scheduled for next week with a list of witnesses. If you can provide that to the committee and the clerk, that would be appreciated. Before I go to Ms. Hepner, keeping in mind of time, I really need to get this budget approved. So if I can do this now, and I'll go to you in a second, Lisa. We've got a budget for foreign interference in the amount of $9,850. Is there any question on the budget at all? Can I get unanimous consent from the members? Okay, we've got that. Okay, there you go, Madam Clerk. Ms. Hepner, I may have to cut you off at some point because we did agree to go to 5:30, so please go ahead.
Thank you, Chair. I wanted to advise the committee that I am opposed to this motion, and I will outline the reasons why. First off, it's an interim position for 6 months. Ms. Richard has been in that office for more than 10 years. She served as number 2 to the previous Mr. Dion for much of his term. So she is the most obvious choice to replace him on an interim basis. She should already have an invitation to appear on the mains. And I don't understand why we would invite Minister LeBlanc for this particular question. He is not the minister responsible. He recused himself from the decision. He would have absolutely nothing to say as part of this discussion. And I think, I think the final point is timing. We already have a number of studies underway. We're involved in important studies on access to information. We have other studies that have been proposed that I think are very important, like the TikTok study. And so when this motion talks about immediacy, it gives me pause. It makes me wonder what we're putting aside for something that's really just a partisan dig and has no relevance to anything important that we're doing here.
Okay, thank you, Ms. Hepner. Mr. Fergus, I have you next on the list, and again, keeping in mind of the time, I may have to stop you and adjourn the meeting. Go ahead, Mr. Fergus.
I won't take up much time. I just want to reinforce my colleague's second point in the fact that the minister, as we all know, recused himself from any decision on this, was not involved in any way. This decision, I'm not certain what we would get and how we would be spending the committee's time by inviting him to come here just for him to say, I don't know, I wasn't there, because of the recusal that was put in place and a recusal that was publicly known to everyone. To the third point, Madame Richard served in this post when the previous ethics commissioner was ill when he took a leave of absence. So it wasn't a problem then. I'm not certain why it's a problem now. Thank you, sir.
Okay, thank you, Mr. Fergus. I don't see any further discussion on the issue. Sorry, I do. Mr. Green?
Yeah, I want to go on the record about this. And again, this isn't about impugning somebody who clearly has worked in this department for quite some time. But I can't fathom a scenario where the commissioner would have to recuse themselves for the purpose of a perceived conflict of interest. I think that fundamentally erodes the faith in the institutions that we should be restoring. And I have a hard time believing that in a population of ours, we couldn't find another person who, regardless of whether there's a conflict of interest or not, if there is a perception of a conflict of interest in the public's eyes, that's a problem. And I just don't understand why this government proceeds to continue these own goals, these self-owns. And I would hope that through the course of this study, and not only that, but to put the pressure on the person who's been appointed with the asterisks beside them for the entirety of their term is also not fair. So, I would hope that the government or perhaps the commissioner would come to a more practical solution on this particular matter, which is why I will be supporting this motion, because I think it's a completely unnecessary thing to do at a point in time when our democracy is fragile and there's a cynicism out there. So I'll be supporting this. Thank you.
Okay, thank you, Mr. Green. Mr. Villemure, petit intervention.
A brief comment, please. We're going to have to leave at 5:30. Thank you, Mr. Chair. I will be very brief. For conflict of interest, I learned a lot as working as an ethics advisor. Everything needs to be clear for a reasonable person. I think that in this case, a reasonable person would have some doubt, and I share that doubt, and that is why I will also be approving the motion.
Monsieur Villemure, it is 5:28. We had an agreement. Did you have one more intervention, Mr. Barrett? No? Okay, so I don't have any speakers. I mean, we can proceed to a vote on this if you like. Okay. Madam Clerk, can we have a recorded vote, please?
Recorded vote on the motion moved by Mr. Barrett. Mr. Baines.
I vote no.
Monsieur Fergus.
No.
Ms. Hepner.
No.
Mr. Jouari.
Opposed?
Mr. Casey.
Opposed?
Mr. Barrett.
Yay.
Monsieur Gourde. Mr. Carrick.
I vote in favor.
Monsieur Villemur. Mr. Green. And so, yeas pour 5-5, nays contre 5-5. Mr. Chair?
I vote in favor.
So, yeas 6 pour 6, nays contre 5-5.
Okay, the motion carries. Thank you, everyone, for today. The meeting is adjourned. We've got to go vote.